Hi everybody, welcome back to the 10th of an hour with Griffin Bridgers. For today's episode, episode 66, I'm going to switch away a bit from the usual tax-related subjects I like to discuss, and I'm going to dive into the weeds highlighting a recent Oklahoma Supreme Court case and show that as little as you think this would be an issue, there could potentially be conflicts within a family when it comes to a lack of clarity with funeral and memorial instructions and how important it is to make sure that these issues are addressed in a proper and enforceable way within your estate planning documents. Now, as always, this presentation is not intended to substitute for legal or tax advice. So, this is the part of any client discussion in estate planning that nobody really wants to dig into and deal with. It's morbid and unpleasant to ever think about funeral instructions, especially disposition of last remains, and a lot of people just leave it up to oral instructions among the family members and think that, oh, their spouse or their children are going to know what their wishes are based on obscure past conversations. But just because you tell somebody what you want to have happen doesn't mean that that person is going to carry out your instructions. In scenarios where there should be utmost respect and reverence, those are the areas where family disputes tend to rear their ugly heads, and it's usually a certain level of projection as well, where, there's other family issues and disputes that are getting projected onto this battle of how do we carry out what should be clear funeral instructions. So, if your instructions are oral and not written, how are things handled? And this is going to vary state to state, but I think it's going to highlight the importance of being sure what your state's laws say and making sure that you put into place instructions that are clear. And as we're going to see, it can help because you don't necessarily have to have an unpleasant conversation. You can just have a written document where you make your instructions clear and your intent clear. So especially if you're in the middle of a divorce or if you have a family conflict maybe between children or anything like that. And there was a recent Oklahoma Supreme Court case opinion in re Estate of Foresee. And in this case, we had a situation where the surviving spouse filed for divorce and moved out. And then the case wasn't clear as to when this diagnosis came down the pike, but the decedent was diagnosed with Lou Gehrig's disease and updated his will, and then died probably a couple weeks later. And in that will, he disinherited his divorcing spouse because the divorce had not yet been finalized and still hadn't been finalized at the time of his death. And he also named his two children as his co-personal representatives. So, after he died, the children filed a petition to be named as special administrators in order to have the authority to carry out his oral instructions regarding the disposition of his last remains, but the divorcing spouse stepped in and challenged their authority, asserting that she should be making the call and that the will and the appointment of the children had no real effect, that, since the will didn't expressly on point contain instructions as to how he wanted his last remains to be handled, that she should be the one to make the decision. But the trial court, the appellate court, and the Oklahoma Supreme Court all upheld the finding that even though there's no express written direction in the will, there also was no outside express written direction either. So in that case, when you don't have an express document that says, how are my last remains going to be handled, in that case, there's a certain hierarchy of who they look to. And actually, number 2 on the list were the personal representatives named in a will or other testamentary document, and after them, 3rd on the list was the surviving spouse. So, in this case, it was just a matter of hierarchy that the court said yes, the children's authority as personal representatives, if it is indeed valid, would override the authority of the surviving spouse in this case. Now, the surviving spouse had argued that that the will wasn't valid, that it was the product of undue influence, and usually when it comes to the validity of the will, especially when it comes to the distribution of property pursuant to that will, the court would dig into that undue influence claim. But here we had a situation where there was, injunctive relief, emergency, appointments sought because you want to hurry up and honor the decedent's final wishes and not drag this out for months. So in this duress type of scenario, what the court really said is they looked solely to whether the will had actually been validly executed under Oklahoma law and found that it had. So the authority of the personal representatives under the will was found to be valid, and as a result, the personal representatives were able to make the call as to funeral instructions and disposition of last remains. So, key takeaways here is that it's usually a good idea to have a written notarized document expressing your final wishes so you don't end up in this situation, and that counts double in any sort of scenario where you believe there could be conflict between family members or even former family members, such as with a pending divorce or an intra-family dispute maybe between children who may not agree on how to handle a parent's funeral. So, as a first step, you should make sure you know your state's laws as to who has authority and how does that intersect with any sort of written document. And despite what this ruling says, a lot of attorneys take this position, and I take this position as well, that it's not a good idea to include your funeral instructions in the will just because, like we saw here, there could be a delay in probating the will and getting those instructions into place. So all this could have been headed off at the pass, and there would have been no need for a Supreme Court decision in the Oklahoma Supreme Court here if there had just simply been a written statement of intent regarding disposition of last remains. Now, as always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you for listening to this episode of The 10th of an Hour, and I look forward to seeing you in the next one.